My name's Sam. I'm a lawyer in the Contentious Trust and Probate team here at Whitehead, Monckton, which sits under the Dispute Resolution team. So there's quite broad requirements to an extent. The first one are formalities with the actual signing of the will by the person making it. So there's legislation which provides how it should be signed. Just very briefly, that's signed by the person making the will or by someone at their direction. And this is usually done in the presence of two witnesses who must also sign and attest. There's some further provisions, but that's it generally. The other requirements will relate to the circumstances surrounding the will. So a person must have testamentary capacity to make a will, and that's set out by case law. They must understand that they're making a will and the effects of that, the extent of their estate. Also, they must appreciate any claims that people may have against their estate, and they must also not be suffering from any delusions which may affect the dispositions under that will. You then have knowledge and approval, which flows from that. Knowledge and approval is presumed where a person has mental capacity. They must know and approve the contents of the will. And then there's also sort of the higher thresholds of undue influence and also fraud in the case of just a document just being presented as a person's will which was never signed or made by them. So they're the main ones. Usually, I said broad about the requirements for a valid will is because usually the investigative steps are usually the same. So usually if you've got any issues with the signing of the will, usually this more relates to homemade wills. Usually professionally drawn wills are usually signed at the offices of a firm of solicitors or will writers, and so they comply with formalities. If it's a homemade will, you look to request statements from the people who witnessed the will, just to check that the requirements were complied with. In relation to sort of capacity claims and knowledge and approval, usually you'd start undertaking steps. You'd certainly insert something, register something called a caveat with the probate registry, just to ensure that no grant of representation can be applied for under the will that you're contesting, and that remains present for 6 months and blocks any grant from being issued and proving the will whilst investigations are sort of undertaken. And those investigations are usually, if the will has been professionally made, you can make a Lark v. Nugent statement, which is ultimately guidance by the Law Society, that a will drafter, where there's suspicions around the validity of a will and it's been professionally made, that they disclose their will file, which would comprise of attendance notes and other documents which may give rise to the circumstances around the time the will was made. You'd also take further steps, so requesting medical records for the person who's died, to review them, especially on the point of capacity, and anything that gives rise to as to whether they'd been diagnosed with any mental illness. And you'd also take as many steps as possible to try and get as many statements as possible from people who may have been present and known the life of the person who passed away, and seen anything suspicious that may have gone on or knew them on a day-to-day basis, i.e. neighbours, and any concerns or changes in patterns of behaviour which may give signs that they didn't meet the requirements of the testamentary capacity test, or whether there was any potential undue influence that may have been present by a particular person. It can be time consuming to undertake those initial steps, and there's no sort of immediate quick result of obtaining them. It can be quite lengthy. It usually depends on the volume of the documents that are returned in terms of the person reviewing that and assessing the merits of a case as to whether a person has a claim or not. Usually once you take those initial steps and you've got the caveat lodged, which the caveat acts as leverage ultimately, to buy time in investigating matters, and then move into a position of writing a letter of claim if there are real concerns as to the validity of a will. And then it usually depends on the merits of the case and also the conduct of the other party, as to whether it can be progressed efficiently and in a cost-efficient manner. So it usually depends on the steps required to investigate it and the volume that comes back from those investigations, and also, of course, the complexity. If there's, because it's quite broad, that these requirements for the validity of a will, that's sometimes as the complexity and the amount of work involved, and more so the legal issues at hand. These type of cases, they tend to settle prior to entering any court proceedings. Again, it comes down to the conduct of parties on the other side, and whether negotiations can be entered into early on. Usually, a factor of that is the merit of the case and the evidence that's been gathered. Depending on whether you're a defendant or a claimant, sometimes that's out of your hands. But usually, these matters tend to be resolved by way of alternate dispute resolution, so through mediation, in which can assist with early settlement and without the need for court proceedings, which are very costly in themselves, and they also have an impact on, of course, the costs if you're required to issue your claim or not. Sometimes if you have a caveat, then there is a process where there's a formal process with the probate registry where something known as a warning to that caveat can be entered into to basically get the person to remove the caveat if they've just sort of put it in there to cause a bit of disruption and don't have many merits behind their claim. But if you enter something called an appearance to that warning, then ultimately the caveat becomes locked, and a probate claim can very quickly follow from that. Although those are very basic steps, through taking those steps, things can very quickly escalate into ultimately court proceedings through the registrar. So it's probably best in circumstances to take initial advice and discuss the matter through first before taking any of those steps that I've set out.